So we also will be using this photo there. I always look for pictures. So let's get started. Well, Verehrte Damen und Herren, ladies and gentlemen, I welcome you to the EU law workshop, second workshop of this year, and we are very, very glad, honored to have Sophie Robin-Olivier here of the Sorbonne University speaking to us on a topic that is very important for everyone, but universities in particular, as chain of contracts, something that when we hire people keeps lurking around, limiting our opportunities. So we very much look forward to your presentation. Before that, just two words on Sophie. She is with the Sorbonne School of Law, but is also Directrice of the Sorbonne Research Institute for International and European Law, has been a visiting professor at many institutions, in particular one of the institutions that also connects us, which is the Collège d'Europe in Bruges, but also in the US and many other places. And she's a specialist with a research focus in equal treatment, non-discrimination law. Also, of course, labor law. You were the FIDE rapporteur in 2023 in Sofia for EU social law. So a very, very distinguished scholar on the subjects that I mentioned, and also a subject that she will be reporting on today. And also recently, we just discussed that you have moved into the area of climate change and the impact on social rights and climate change. So we're very glad and lucky to have you. And before we start with your presentation, just two housekeeping remarks. One is on the fact that we are streaming this event. So there is audience online. If you are online and you wish to partake in the discussion afterwards, please type your questions into the chat. So there is no voice intervention possibility, but if you type your questions, we will select them and read them out to Sophie. And also for the audience who is here, if you wish to intervene in the discussion afterwards, which I very much invite you to do, please feel encouraged to discuss with us. Please do use a microphone, otherwise people following this event online will not be able to hear you. Second part of the housekeeping remarks, expression of gratitude, again in two parts. Number one is my team, who's made the organization of this event possible. Without their help, I couldn't have done it. I see Rose Franzen here. There is Barbara Marco, probably not here, but she's still thanked. Patrick Marek, Kerstin Schatz. Downstairs or back changing or managing the equipment, Adnan Tokic. Thank you very much for assisting in the organization of this event, and also the culinary wonders, the food and drinks that you are enjoying are courtesy of Zera Hemper law firm, today represented here by Magister Nina Neumeier, back there. So thank you very much for sponsoring this and also the other EU law workshops. We are very grateful to your law firm. And with that, finally, I give the floor to Sophie.
Thank you. Thank you very much, Thomas. And it's really great to be here. And so I thank you very much for the invitation. I'm delighted to share some ideas with you. It's a great pleasure to be in Vienna. So thank you. And I suggested a topic that I thought might bring together labor law specialists, but also other specialists of EU law and people interested in EU law more generally. It's a topic that crosses some of the borders, the limits of the fields, disciplinary fields like labor law, corporate law and other aspects of EU integration. So that's the reason for the choice, really, basically. So I'm talking about chains of contracts. It's a bit technical. It could be, if you take it from the more economic perspective, you would say it's about supply chains, this global supply chain. In fact, so the idea is to talk about the phenomenon that has taken place in recent decades, this organization of production through subcontracting, and subcontracting internationally, more particularly, and the fact that it has an impact on different aspects of social, environmental, economic, of course. For me, I'm more interested in these, as you understood, by labor law issues, social protection, and also climate change. So yes, what I started looking at, and it's been a long time, it's a long story, really, the question on how we're going to discipline supply chains. And why I'm saying that is because it has appeared that the globalization of supply chains and supply chains themselves, even nationally, or at the European level, are problematic for the protection of workers and also for the environment, but for the protection of workers as a matter of fact. And the reason why is the organization of production through these supply chains has this impact that workers that are contributing to production, to the final product or service, are not contracting directly with someone who can be called the employer. And that for labor law is a central, it's a pillar, is a major element to determine protection. You need to be related with an employer to be protected, and that's basically the case. I'm not talking from a French perspective, European only perspective. It's more general, this approach, that there is a condition for benefiting from protection on a labor law perspective, which is to be bound by a contract with an employer. So this is very problematic when there's a chain of contracts and the worker contributing to the final good or service is, down the line, far away down the line. So not connecting with the one who has, in fact, the power and resources to ensure protection. So that's, because you might think, yes, but the worker has an employer nonetheless down the chain. Yes, but that employer down the chain is not necessarily the one that can ensure protection for different reasons. So this is, something that I'm not the only one to say. Indeed, this problem that is related to globalization and the problem of labor law itself, the fact that, and I'm quoting here Brian Langille, who is a specialist of labor law, particularly the international aspects of labor law, and saying, criticizing labor law itself, the conception of labor law, because it is based on this notion of a contractual linkage or linkages. And that has this consequence that it is an incentive to decontractualize labor law and relationships, and to use globalization, he says, hyper-globalization, as a method to avoid labor law. So because labor law has remained limited in its scope to direct relationship with an employer as a condition for protection, it has fostered developments that tend to put workers in a distance, by separating them from the actual beneficiary of the work. And in addition to that, making it international, that it's even more complicated to bring it back in the scope of protection of labor law. In reaction to that, there is an interesting recent element that serves, it's a justification for today's presentation, which is this European Parliament resolution that we'll quote a couple of times during this presentation. I don't know if you heard about this European Parliament resolution that was adopted in last February, dealing with subcontracting chains and the role of intermediaries in order to protect workers' rights. So it's very much the perspective that I'm having today, that the European Parliament has looked at. And I'm quoting this. I think it's important because it's a way to explain what I'm trying to explore today. The Parliament underlines that labor exploitation and abuse in the EU labor market. So I'm pointing at that because Parliament is looking at the EU market situation, the EU internal market situation. So labor exploitation and abuse in the EU labor market constitute a serious problem in high-risk sectors, manifesting in various forms, included but not limited to work-related crime, undeclared work, illegal work, the grey economy, social dumping, labor exploitation, and modern slavery. So there's a group of issues that the European Parliament put together and connects with a chain of contracts. It also points at the fact that this happened, these problems that are related with chains of contract, with decontractualization of relationships and hyperglobalization, as Angie says. This happens particularly in certain sectors that are called high-risk sectors: construction, agriculture, hospitality, domestic work, transport and logistics, meat and food processing, cleaning services, and care work. This is important too, because I pretty much think that you're aware of that. There are sectors where things are not as they should be in terms of labor protection. We basically know which sectors, but how to deal with it is another story. It's problematic. It's been difficult. According to the European Parliament, in these high-risk sectors, labor exploitation is related with high labor intensity combined with long and complex subcontracting chains. That's very clear. And it says it's both supply chains that are horizontal and vertical, which create problems. Why problems? Because it blurs responsibilities, it impedes awareness raising, and complicates the enforcement of applicable labor law and collective agreements, as well as the checks for work permits, social security contributions, tax payments, and the identity of workers. So all that ensures protection of workers, traditionally in relation with an employer, all that is made more complicated by the existence of supply chains and chains of contracts, diluting liability of the employer. In this context, the Parliament remarks, some member states have adopted legislation in order to limit the length of subcontracting chains, or even to ban completely, in certain sectors, the possibility to subcontract. That sounds, I don't know what you think about, that sounds very rigorous in terms of business law approach, of freedom to conduct a business, I might say. To ban subcontracting for businesses, that's tough, isn't it? But still, that's the case. Maybe you have some idea of what's going on here in Austria. I don't know. You know how subcontracting is regulated in France. That has not been the case. That subcontracting has been limited or prohibited. And I think that would go too far in terms of freedom to conduct a business, free enterprise. I'm not sure it would be constitutional in France to ban. I mean, it would have to be limited and justified really in depth so that it's made possible to balance it with free enterprise. But I know that in Germany that happened, that Germany banned subcontracting for workforce, to provide workforce in the domain of in the sector of meat, meat in general, and particularly, and I don't have the name for that, but when you're dealing with preparing from the animal to meat that you're selling to consumers. What's the name for that? This industry where processing. And that's a very dangerous sector. Nobody wants to do that. It's not well paid. So there's a lot of workforce coming from other member states or from outside the EU in the sector, and lots of problems in terms, particularly of health and safety. So many work accidents. It became so terrible that Germany adopted a couple of years ago a regulation that prohibits temporary work in the sector and prohibits not hiring directly workers in the sector. And it seems to be working well. In any case, this is what the European Parliament noted, that there has been regulation in some member states, not yet at the European level, but the European Commission seems to be aware of the problem and seems to be considering, based on a study that was conducting or requested by the European Commission, European Commission seems to be aware now that there is a need to limit the number of levels in subcontracting chains, at least in some sectors, to ensure liability of the beneficiary of this operation and protection of workers. So that something should be done, but it's complicated, it's tricky, because it has to go along at the EU level, just as at national level, with the fact that we're functioning in a system where freedom, individual freedom, and freedom to conduct business is so important. So it has to be very light touch, or very very well justified in order that this is possible. But that's there, that's coming. It seems to be. I'm not sure. I'm not going to say there is going to be something out of the Commission's, box for proposals right now. But I'm saying at least there is awareness. It's not always been the case. But if you look at the institutions, European institutions now, the European Parliament voting on the resolution, the Commission being aware, conducting studies, being somehow more favorable to changes in the domain. Also because member states are, now addressing the issues in isolation, which is always problematic at European level, as you know. That member states start doing things on their own, and that complicates the functioning of the internal market. So then of course, that leads to some kind of reaction at the Commission level. So my purpose here is to look at the EU reaction to this problematic development of subcontracting chains, global supply chains, subcontracting and internationalization of the production through subcontracting. What was the reaction so far? And the second question I would like to raise is, what does it tell us about the EU evolution on that? What the evolution tells us about what the EU has become. It's a big question, just a little bit of that towards the end. Firstly, it needs to be noted in the beginning, I think, that there is this big tension that the EU is facing, maybe even more than member states, due to the fact that free trade, or the internal market even more, is the basics. I wrote the DNA of the EU because it's very strongly inside. I'm not going to say the internal market is not the cement. It's true. Everybody, there's consensus on that, isn't there? That the basic, the cement of the integration is the internal market. It's very hard to, yes, of course, it has evolved a lot, and it's not what it was anymore. It's been tempered by other interests, objectives, etc. But still, it's very central. So that's an important aspect. And the same is true, although it's lighter, it's not as important at international level. The notion that contribution of the EU to international trade is important is evident when you look at the objectives, the description of the objectives of the Union in the first articles of the Treaty on the European Union. The objective to contribute to, it's true, it says free and fair trade, but free trade is there and its contribution. And I guess in the current context, when you see free trade is so much challenged at the international level, it's very hard for the EU to react to that. Although it has started to do that, there are major changes going on also at the EU level, maybe even before the recent transformation, due to the US positions. Even before that, due to climate change, sustainability objectives, the EU has started taking a different direction in terms of free trade. But it remains the case that it is the basic conception of the EU was both the internal market and, second, to contribute to global trade, free trade. And so, that remains super important. But at the same time, you have the notion that the EU is also a social Europe, that there is a social policy. It has grew in importance, particularly in current times. There was this European social pillar, and lots of legislation developed. Yesterday we were talking about the minimum wage. All kinds of developments took place through time, and at moments, more evidently, the European social policy became central. And more recently, it went along with sustainable development. As you probably know, sustainable development involves the environment, climate, but also social matters. So it's based on pillars, including social protection of workers in particular. So this is the balance that has to be taken into account, the different interests and the tension that exists between them. And in this context, or in this, maybe I should say, against this background, there are different contexts within which EU law has tried to provide solution or tried to cope with the fact that there was a problem with workers' protection and social security and social systems protection more generally due to this development of production along certain lines, including international subcontracting. So the first, and this is where I will probably spend more time, the first context is the context of posting of workers in relation with free provision of services. This is kind of classical. I don't know how many of you heard about that domain, but it's classical both for labor law specialists and for internal market specialists. It's a big issue. It has led to lots of cases in legislation, EU legislation developing to try to find a good balance between the internal market and the protection of workers. And it's not only a situation where, this is the classical Laval and Viking situation. You're trying to use, and a corporation is using free provision of services. That's usually how you present it. I don't know about those who teach these classes here in the room. But usually the presentation is, free provision of services is for corporations in the EU to be able to provide services across the internal market. So to use this freedom to develop their activity internationally, where I'm not looking at that from that perspective. As you will see, I selected cases that show that this is, of course, this is what is going on for a part. But what is also going on is free provision of services has been exploited or used by corporations to just, decontractualize their relationships with workers and internationalize it. So it's a different perspective. You're looking at this from a different angle. You're looking at, and you'll see from cases. I'm not going to say much more now. So that's the first context I would like to look at. And then there is a second context, and it's not obvious that it's connected. That's the development of sustainability reporting and due diligence obligations by the EU. And there were two directives that were adopted in 2022 and in 2024. There's two directives on sustainability reporting and due diligence. You also know probably that there was an omnibus recently, an omnibus 1, which shrunk the obligations and the scope of this directive, but nonetheless, they remain. So what I'm going to say is a bit less interesting, I would say, hopefully not, still interesting, but it's less interesting in the sense that it doesn't cover so much, it could have been more efficient. But the concepts, the concepts that were put in place in these instruments, these new instruments, they remain. And I think they connect in interesting ways with the way we deal with international provision of services. So let me start with this. This is my idea here. I'll say it in the end. Okay, let's say it now. This is teasing, but maybe I'm going too far. It's less a teasing than it should be. It's, my idea, hypothesis, is that the sustainability instruments have somehow freed EU law from the straitjacket of the internal market, the limits because it's separated, because it's not been seen the sustainability instruments. They're looking at the global level, they're not looking at the international level. And so somehow it's not being seen as a problem for the internal market, but you may think different. That's my impression, that they've not been seen as limits to the internal market. So it's been okay, to adopt these instruments without thinking, oh, maybe there's a problem in terms of restriction to freedom within the internal market. So that's the idea. That there is something going on that's not been obvious, that's not been seen in terms of the impact on the international market, but has led the EU to new concepts that are probably more efficient, or could help at least in regulating the global supply chains and the series of contracts that exist. So first, the classical aspect, the regulation of the freedom to provide services in order to combat workers' exploitation. In this context, there are different types of problems, I would say. There are problems that are just resulting from the normal use, the normal application of freedom to provide services. There's nothing to say about the regularity of what is going on. It's fine. It's in conformity with the law. It's nonetheless problematic in terms of labor protection. And then there is fraud that's added to that. But I would say this is not necessarily fraud that is problematic. It's the system itself that is problematic in terms of protection of workers. So let me show you a few cases. I'm not going to go into that, this evolution, because I see time is flying. So, but just, there's an evolution, there's a big moment, Viking and Laval, but Viking and Laval have basically nothing to do with what I'm telling you about now. It's a different situation. It's the normal operation of free provision of services that is going on. But then it led to reactions at European level towards greater social protection. And that we've seen that particularly amending the directive on posting of workers in 2018, that has to do with the Laval and Viking moment. Now, I wanted to show you some examples to illustrate what I'm saying, what free provision of services has become, and how it has led to, putting workers in a distance from the beneficiary of the work. So one example I thought was appropriate because it concerns an Austrian firm that wants to construct a wire rod mill. Don't ask me what it is. I looked at the translation. It didn't help much because I still didn't know what it was. Some kind of technical device. But in any case, this Austrian firm wants to construct that wire rod mill in Austria. Instead of doing it itself, it's subcontracting to an Italian company, Danieli. That sounds fine. I mean, Danieli, the company, is an Italian company and should be able to use free provision of services to provide services in Austria. That's what the internal market is for, isn't it? But it doesn't stop there. Then Danieli, he wants to employ Croatian workers together with Russian and Belarusian workers in order to fulfill this obligation. And to do that, it's not going to hire these workers. That's just a problem of immigration, you would say. After all, if Danieli wants to hire Russians or Ukrainians or Croatians or whoever they want, it's an immigration issue. If they can do that in Italy, why not? And they should be able to move with the workers. Now, there are issues in terms of immigration in this context, but let's set them aside for the moment. In any case, that would be okay, except that Danieli is also part of a group of companies, including a Croatian company and another Italian company, which is the one employing the Russian and the Belarusian workers. So you see what happens. There's the construction of a chain of contracts, and different chains, in fact, because you have the Croatian company, so that makes Austrian, Italian, Croatian, so that's the internationalization of the chain, one aspect of it. Second aspect is Italian, it's Austrian, Italian, but still it puts the workers in a distance, because instead of Danieli, the first Danieli, hiring the workers and bringing them to Austria to build the mill, it's the Danieli automation that contracts within the group with Danieli, which provide the services. So the line is longer And it's bizarre, no? I mean, I'm not going to say it's a fraud. It's not necessarily a fraud. It's just, why is it that they don't have these workers? Why is it that Danieli, the first Danieli, is not hiring the Russian and the Belarusian? Why? If not, to limit its liability with the workers by having a subcontractor. No, and that's an open question. I'm not saying that, that this company is problematic. I'm just saying there is a question about why companies are doing that. And it's not only Danieli, of course. This is a serious, it's becoming a norm. It's a model that is applying. It's a mode of production. And once some companies are doing that, if it helps, getting the contract with the Australian company, why won't you do that? And there are, in the meat sector, this is happening very much, that you're doing that in order to avoid hiring workers directly, because liability is high. So this is what is happening in Danieli. And in Danieli, the solution doesn't matter so much, but if you want to know, the court, maybe I'm back. The court said, it's okay for Danieli, this is all okay, except that the Austrian, because they protested, the Austrian labor inspectors, that there was something bizarre in this situation. They didn't know, whether they could ask for work permits, what kind of legislation was applicable, social security issues. And basically the Court of Justice said, yes, it's possible to limit in the sense of require that there are some documents provided so that workers are protected, and the Austrian authority can control that this is not a system of exploitation in ways that are not acceptable. For instance, there would be forced labor or these forms of very tough exploitation of workers. So it's possible, according to the Court of Justice, that the Austrian authority somehow control what is going on. But it doesn't mean they can prohibit the functioning of this chain of contract. They just can control that workers are protected in some ways through requiring some documents, some information about the workers. Now, this is a problem, and the worst problem, I might say, the most problematic is the organization of this provision of workforce across the labor, across the internal market by temporary work agencies. This has been going on since the late 60s. So it's not a new situation that there are temporary work agencies providing workers around the EU. The development that is, according to me, problematic is that it became a business per se, not to do temporary work. Temporary work agencies, they've been around for a long time. It's to internationalize the process in order to make provision of labor low cost. So for instance, and there's a case about that, it's called Team Power Europe. My plan was to show you a slide on that, but for instance, and you're very much concerned here in Austria, like the Germans, to set up a company that does temporary work in Bulgaria, and through that to provide workforce to companies in Germany, mostly, or Austria, without doing any activity in Bulgaria. So it will be, you're creating that in order to shift workforce around the EU, or in particular member states where there is a need for workforce, and possibly workforce that is not too costly. And because there is pre-provision of services, it's basically possible to do that. Because as the court says in all these cases, provision of workforce, loan of manpowers, as it says in SN, the last case here, loan of workforce is a business activity. And because it's a business activity, if it happens beyond borders within the internal market, this should be feasible. This should be acceptable because that's what we want. Business activities extension within the internal market. So you have all these cases where, including Danieli that I mentioned before, where the court had to struggle with that. Yeah, this is business as usual, but this is business that creates particular problems because business is about providing workforce. So yes, it's the same type, it's business, indeed. You make profit with that. But it looks like, not slavery, but no, because they could be treated in good ways, these workers, but it still is. You're providing workforce. It still is, you're shifting workforce around. Where it's low cost, to put it where it's, it's needed, and it's, it's going to be possibly exploited. And exploiting, there are different meanings of it. It's not necessarily exploited in terrible ways for workers. It could be just exploitation in the sense that, that you make profit through getting access to this workforce. So, but this is what's happening, and that there are a long list of cases where you can see, and I won't go in depth into that because it would take us an hour or so or more to explain how the court has dealt with that by saying, this is business, but this is business that is different here. The court in the last case, eventually, the court says in 2024, there is a specificity of the loan of manpower. And that means specific rules, possibly. But specific rules here only means in terms of immigration. There is a possibility to require permits, work permits. So it doesn't go very far. It's just about that, because that was the issue in the case. But still, the court notes that there is something specific. I won't go too much in depth in social security issues, but this is an important aspect of it. And Team Power Europe, as I mentioned just before, is bringing together the issue of temporary work agencies and the exploitation of differences between social security systems. Some are costly, some are less costly. So that's why Bulgaria is a good state to choose to create a temporary work agencies like Team Power Europe did, because you can affiliate workers to Bulgaria and the Bulgarian system and then shift them around, where it's much more costly if you compare to Germany or France, where it's particularly costly in terms of social contributions. It's a very good idea to have the workers affiliated in Bulgaria. So yeah, that could go, continue like that. But the court, in fact, in cases, Team Power Europe in particular, the court, it's here. The court said, we need to do something basically at the EU level, because otherwise there will be a race to the bottom. It's already taking place, and there is law shopping taking place, and that's problematic not only for workers who are exploited in the context, who are not getting what they should get in terms of protection. It's also problematic for the social systems themselves, because it draws the companies to certain states where contributions are paid, and in other states there's no contribution or less contribution than it should. Of course, you will say, well, but then they're not paying pensions, or they're not getting benefits, so maybe it's balanced. It doesn't seem to be the case. It's not exactly that. You need contributions, especially when I'm talking about pensions. For instance, for us in France, if you don't get workers to pay now for pensions of people, being retired now, then there's a problem of, the system doesn't work because of our system. So you may say it's our fault, but it still is problematic. So the court now, in 2021, Team Power Europe, the court is aware that there's a problem and that there is a need for limiting this organization of production to avoid a race to the bottom. That is indeed problematic. There's another case I wanted to show you before moving on, is the Bouygues Travaux Publics. It's a very good illustration. I don't know if you heard about that case. It's still back in time a little bit, 2020. And the situation took place longer before. But it's an interesting case where you see that, it's Bouygues, it's a big corporation. Bouygues, I don't know if you know Bouygues, but Bouygues is a big French corporation that's developed in different fields of activity. It's kind of powerful, resourceful, and he obtained the contract to build the Flamanville nuclear reactor. And so you think this is something dangerous, this is something important, very costly, that has all kinds of impacts, societal impact. And what Bouygues did is it created a group of companies subcontracting with this group of companies. Some of them are established in France, well-bound, but some of them are established elsewhere, particularly in Romania and in Poland. And what do? They provide workforce to the site, the construction site in Flamanville. That situation, that organization, you see how it's organized as a network of contracts. It led to complaints on different issues, accommodation of workers, disastrous. So that leads to, that connects with the idea of forced labor in the sense that, they are treated like without dignity, let's say. So it's about accommodation. There were strike actions, although they are very precarious, these workers, they nonetheless went on strike. There were lots of accidents, work accidents, on a nuclear site. So protection was not sufficient, and these accidents were not very often reported to the authorities. So eventually the police and the specific authorities in charge of nuclear security had information on that and finally reacted, after a number of unions and activists had said, this is not okay, this is not going right. Eventually, there was a case that was taken to court, to French courts, on concealed employment or dissimulation de travailleurs, dissimulation d'emploi. It's concealed employment, illegal employment in a way, and also unlawful provision of workers. And both Bouygues and Elco were charged with criminal liability, and they were condemned in the end. So, but why the case went to the Court of Justice is there's a problem here, because these companies were they looked fine on the paper. They had obtained that the workers were affiliated to Polish or other, the social security systems where the workers were supposed to be employed. So there was affiliation to social security system. They were on the French territory, and dissimulation of employment means, partly that the workers are not affiliated to a social security system. So I know it's a bit technical if you're not social security specialists, but it's just, it was not clear that they could be charged with concealed employment because they had these certificates that the workers were affiliated somewhere, regularly affiliated to a social security system. Now, the big question here was whether the notion of concealed employment in France was only about social security, or it was in addition something that concerned labor law, so dissimulation of employment in terms of, labor law issues. And if so, it was not sufficient that they had certificates that they were affiliated somewhere else to protect the company from being charged with concealed employment. So that was all the discussion before the court. And luckily, the court said, that's for the French to see what exactly it is concealed employment. If it is not only about social security, then they can apply. And Bouygues was condemned. So it was condemned for criminal matters, but then the social security system jumped in and said, well, maybe we should have been the ones to benefit from contributions. So this is even worse, I guess, for the company because it's very costly if there is a claim for social security contributions for a number of workers after a number of years. So these are just illustrations of what is going on, and I could add cases, but I won't because it's already late. But the road transport is one field where you see the same pattern going on. It's very problematic because EU law in this matter is, has evolved recently with the road transportation package of regulation. It's complex. I don't think it's efficient, but that was in road transportation, like in other fields, transportation is problematic. International labor exploitation in transport is a large issue. It's very hard to regulate, in particular in the internal market, because of course companies want to continue to do what they want. They want to continue to be able to, shift workers, lorry drivers around Europe to both do international transportation and then cabotage when they are far from home. So that's fine, and that's good to do that without having to apply Belgian, French, German, Austrian law. So possibly if the companies are created in eastern part of Europe, where it's less costly to affiliate workers to social security system. Now, there are also cases of fraud, and fraud is complicated because it's hard to define. It's always hard to define. Circumvention of the law would be a definition. Here it's hard to say when really it's circumvention of the law or the application of the law. One definition of it that you find in the EU regulations, the directive, in particular the directive of 2014 on the enforcement of the posting directive, is when there is no real situation of posting because there is no company doing work, activity on the territory of another member state. So that would be fraud to posting, because there is no, like in Team Power Europe, there is no actual activity on the territory of another member state justifying internationalization of production, of service provision. But you artificially create an entity that's doing nothing but just allows affiliation of workers to another system. Or, creating artificially this situation would be fraud. And what to do with that? The directive of 2014 is trying to help with that. There is also, as you may know, since 2019, a European Labour Authority that is trying to deal with that more or less efficiently. It's complicated. What I wanted to point out, and that brings us back to my question, is that in the directive of 2014, there is an article that deals precisely with subcontracting activity. And it's not core. As you can see, it's Article 12. So it's not the central provisions of the directive of 2014. It's not very much. It's not really been interesting to anybody until recently. And recently, I mean, really recently, particularly the European Parliament resolution is interested in that, but that's not been the case before, really much before the European Parliament resolution, that the European institutions were interested in that part. And so it's about subcontracting, and it allows member states, first it allows in the first paragraph, member states, in order to tackle fraud or abuse, to create a system of liability in the chain. So decide that subcontracting, when there is subcontracting in the chain, when the operator that is benefiting from free provision of services is subcontracting, or the principal, like WIG, is subcontracting, it can be liable for this direct subcontractor. It's not dealing with all the chain, but for the direct subcontractor, there can be liability of the principal operator. So this is a possibility for member states. And that goes back to what the Parliament says in the resolution. Some member states exploited that possibility and introduced liability in the chain, like France did. And it was there before, in fact, before 2014. It dates back to the late 90s, in fact, the system of liability in the chain for France. And then there is an obligation for states, this paragraph 2 of this article, an obligation for member states to introduce liability in one high-risk sector, which is construction. In construction, member states must have implemented a system where direct liability or liability for direct subcontractor exists. So it seems to be that more or less all states have put this in place. Now, how efficient it is from state to state is really dependent on the conditions. Liability is a complicated issue. What are the bases for recognizing liability? Now, once you say there should be liability, then the second question is under which condition? For civil liability, it can be rather flexible. When it's criminal liability, that's much more complex, because you cannot, just use presumption, for instance. Yeah? For criminal liability, it's more complex. So, if you look at the French system, how it dealt with that, there's a clear distinction between civil liability and criminal liability. And for criminal liability, there are preconditions. And it's based on, it's not called like that, but due diligence obligations. To create criminal liability, there is obligations that exist for companies to control what the subcontractor is doing in terms of treatment of workers, the situation of workers at the subcontracting. And if the principal company has not checked what happens at the subcontracting company, then criminal liability can take place. But because that creates awareness, you cannot say the principal company did not know, because it had to check, so it had to know. And that rings a bell and connects with, maybe I should move straight to here, with the regulation of global supply chains. Because this is what is required by the two directives, the directive of 2022 and the directive on reporting, sustainability reporting, and the directive of 2024 on due diligence. It says companies have to check, that's sustainable reporting, have to check what happens in the chain of production at their commercial partners. So it's due diligence obligation, in soft way reporting, so collecting information about what happens in the chain of contracts. And the due diligence directive, as for it, creates liability in case there is information that there's a risk for workers in the chain, a sufficient risk, a sufficient important material risk in the chain, then the corporation should take action. Otherwise, it might be liable. So that's where it connects with the service provision issue, the treatment of workers in service, in the development of free provision of services. That the regulation, by regulating global supply chains, the EU might have developed much more extensively a system that allows controlling the chain of production in ways that allow better protection of workers. So the thing is, this is not only about social issues. Indeed, here, as you see in the Sustainability Reporting Directive, it's about social and environmental issues. So yeah, it doesn't look to be, precisely dealing with social issues. Maybe that makes it easier. And, one aspect of these developments, the two recent directives, sustainability directives, is it's interesting that it was not social to begin with. It was because of climate change, really, an environmental perspective that somehow, there was somehow a spillover effect, if I may say that, to use European terminology, that it somehow moved in the direction that led social evolutions to be transformed altogether. But the primary aim was not to deal with social issues. That's my impression. So this is the idea. Also, the idea is maybe that this is not super strong, especially if you, in terms of the type of regulation, especially if you deal with reporting. It's not soft because it's binding. There are obligations on companies, but it's only reporting. You have to be aware, you have to collect information, and then you have to display, to provide this information to the public. But it's not, if you cannot help it, then, okay. So it's, to me, I should not be too ambiguous about that. I think it's very powerful, but it doesn't look so demanding in the first place, maybe, that it's not, when you're dealing with disclosure information, it doesn't necessarily mean, for instance, criminal liability, like what I've been talking about free provision of services. It doesn't mean this kind of instrument. It doesn't mean prohibiting the existence of supply chains. It doesn't require. In the end, it might lead to that, because to control the chain, to get information and to provide information, if the chain is super long, that becomes complicated. To get the information, to know what is happening down the chain might be complicated. So it might lead to restriction of the chain. It might be efficient. Also, because companies become aware, I cannot say they're not aware of what is happening, then liability may be easier to find. So even reporting that doesn't sound to be so demanding in terms of, or so strong in terms of liability, might lead to, important consequences. And what is interesting here, it's, and particularly the directive on reporting, sustainable reporting, is it shifts completely, it transforms completely the notion of workers. And as I was saying in the beginning, the problem with labor law is contract, direct relationship with an employer. Here, when the reporting directive talks about the workforce of the company, the own workforce, it says this includes employees and non-employees. So it's kind of clear that the traditional distinction between workers and self-employed doesn't happen here. And then if you look at the standards, it includes workers in the chain. So workers in the chains, that means workers that are not contracting with the leader of the chain, but all the workers. And let's not hide it. The impact on the leading company is not that it has the same obligations for all the workers, But the transformation, nonetheless important, that it's not as if these other workers down the chain did not count. They can't. They have to be taken into account, and reporting has to be done. So in terms of concept, as I was saying before, even if you limit the scope of application of this directive, which is the case now, it nonetheless means that there is a new conception of working that has taken place that is now, within the legal environment. That is, workers are not only employees of the employer. So that has changed drastically since the reporting directive. And now, of course, the sustainability due diligence directive is a step forward, one more step in the direction of controlling the chain, because now it creates liability. So it's not about only disclosure information, it's creating liability for the leading company. I'm not going to read this, but obligations to operate due diligence, and then civil liability might occur, and other penalties can be applied to the corporations. So maybe something and I wanted to point out really strongly, is these EU sustainability directives. They've been seen and considered mostly in the global environment, as measures that both deal with corporate law. It's mostly for corporate lawyers. And second, they deal with problem of international production or international trade. And so it's not been connected really with internal market issues. It's my impression. But they are very creative. They create a new notion of workers that might impact conceptions that exist within the EU, because they admit that protection is not necessarily based on a contract, not on an employment contract, a particular contract in particular, and they allow a conception of protection that is not limited by frontiers, national borders. Really, it looks internationally, tries to really handle the issue of internationalization of production. And this is connected, although it's not been pointed out very much. This, in fact, is connected with the internal market issue of posting of workers, because if you look closely at Article 12 that I mentioned before, the directive of 2014, it says at point 5, member states may provide that a contractor that has undertaken due diligence obligations as defined by national law, because in 2014 we don't have the two directives on sustainability, shall not be liable. So, we may, discuss on this relationship, but the relationship exists. If there are due diligence obligations, it might lead to no liability, which I'm not, of course, in favor of, this idea particularly, but it just shows that due diligence obligations and, regulating chains of contracts in other ways are related. So my conclusion here would be that we've looked at EU regulation of chains of contracts within the EU system at international market level with lots of limits to the regulation, but still, consciousness, awareness of the problems created by this internationalization of production and subcontracting and chains of subcontracting has slowly been emerging as an important problem that has to be dealt with, and hence the European recent resolution on the matter. But what I thought is, it's bizarrely, maybe it's a paradox, that it seems easier to regulate a situation that takes place at the international level for the EU. It seems easier to emancipate from the ordinary classical conceptions that labor law and the internal market impose, and doing that, looking at the international level, the EU, again, maybe paradoxically, managed to overcome some of the limits. So I'm asking this question to you as a final word, whether this is possible to think that the EU is somehow, when it becomes an international actor, a global actor, is more powerful and more able to provide transformation in the domain of law and transformation of internal policies. So, whether this is a case, this is an idea that we can generalize this notion, and I'm putting this to you, that there is strengths at the international level for the EU when it behaves like a global actor. And that might impact or have repercussions on issues that are internal to the EU, such as internal market issues. So thank you very much for your attention.
Thank you very, very, very much, Sophie, for this inspiring presentation, for the depth, for the liveliness with which you presented the issues, but also thank you for the elegance with which you overlooked that I had misconceived your topic, because I mean, this is a look behind the scenes. Actually, I thought you were going to talk about individual contract chains, that you were talking about intercorporate contract chains, which means that the freedom that we give our speakers here is for you to basically bring whatever is close to your research focus. And I'm very happy you did that, because this was even more interesting than I had hoped for, than I had anticipated. And I do have a number of questions, but I find it very interesting. You shifted the perspective. When we talk about posting of workers, we usually, in Austria, or in the classic discussion from an internal market perspective, we talk about protectionism, dilution of domestic labor standards, so the risk to the domestic workforce. And I liked it very much that you shifted the perspective actually to those who are employed and what happens with them domestically in the internal market, but also on the global level. So I really, really very much enjoyed your presentation. I thank you very much for that. I do have questions. We will also be collecting questions. Maybe I'll just start off with a question of my own, and while we do that, just raise your hands if you do have questions also. The CS3D and the CSRD that you mentioned towards the end of your presentation, that creates liability and imposes other or all sorts of obligations on undertakings. I was wondering, in the light of the very proactive jurisprudence of the Court of Justice on the Charter of Fundamental Rights, but also on the values of Article 2 TEU that we have recently seen, do you think that there is a chance that the existing jurisprudence on third-party effects of binding private parties to fundamental rights standards under the CFR, maybe also under the values clause of the Union, in connection with or taken together with the obligations that those directives impose on private undertakings, could be also utilized by private parties, those you mentioned, enslaved or the workers put at a disadvantage? For example, in a liability situation, I claim damages for the employment conditions that I had, which under older case law, you always had to find a workaround to claim your rights, find an individual claims basis. Maybe the Charter of Fundamental Rights would also provide a basis. Do you see that jurisprudence coming? That would be my first question.
Yeah, it's an interesting question indeed. The problem is with workers bringing claims, really. And it's interesting that the directive on sustainable due diligence had this in mind, and that was raised. That's here. I need my glasses. That this notion that the provisions on liability and due diligence and liability were to be considered mandatory application, overriding mandatory in international cases. And that was very important, because otherwise there's always a risk if you're a worker down the chain and you're employed outside the EU. If inside the EU, there's the EU conflicts of law rules applying. So. But if you're outside the EU, then it's complicated to obtain that jurisdiction takes the case in the EU, because there will be another applicable law, probably the law of the country where the workers are employed in case of an international. So it needs in implementation of the due diligence directive. It will very much depend what member states do. If they consider that this is mandatory, overriding mandatory laws, due diligence, then it allows workers down the chain elsewhere in the world to bring cases within the EU, before a court in the EU. And then that leads to possibly that court using the charter in the context of applying the directive. That would be rational, because since we're applying an instrument that is an EU instrument, then the charter is supposed to be, supposed to be applicable. Now, with which consequences, it will depend, because we have this balance between Article 16, the freedom of companies, basically free enterprise, and on the other hand, other provisions on social rights. We'll see what happens in this balance, but the court could very much use the charter in social ways in the application of this instrument, for instance. But that would require cases to be taken before EU courts, because otherwise, I'm not sure what happens when it's in Bangladesh, or when it's even less, even closer to Europe. But as soon as it's outside the EU, it becomes complicated.
I didn't see that we would also need stronger jurisdiction rules, of course. Like, I mean, we have them in consumer law, we have them in antitrust law, we have them in IP law, spider in the web theory. So we don't, also to effectivize this, actually, we have to come with an enforcement mechanism.
Yeah, because otherwise for contracts, work contracts, there is the regulation, the former Rome regulation, so-called. It applies to work contracts, but it means that the law of the place where the contract is executed applies, basically. So unless this is overriding mandatory requirements that are at stake. So,
do we have questions from the audience?
What says the European Commission in according Article 101 in the competition law against discrimination workers on the single market?
I'm sorry, I'm not sure I understood the question. Okay. Yeah.
You mean this recent antitrust case with the labor, was it non-poaching process? Is that what you mean?
I'm sorry, I'm not sure I'm not sure I know about this. What you mean the impact of antitrust on discrimination? Sorry, but I don't know. I don't know what exactly you're pointing at.
If I may, I'll jump in with yet another question. Sorry, yes, go ahead.
So could you maybe explain again? I didn't fully understand, why are workers, like posted workers, especially within the EU, not sufficiently protected by the domestic labor law of the country where the subcontracting company is situated?
Thank you for the question. And you could have asked that and another, because I didn't explain either the fact that since at least the directive on posting of 96, there is an obligation to apply the law of the state where work is taking place, even temporarily. So yes, for these workers that are hired in Bulgaria, like in Team Power Europe, and they go to work, mostly they work in Germany, German law applies for labor law matters that are listed by the directive of 96. So, wow, they seem to be protected. So, and the second thing is, why am I saying, even if Bulgarian law, for instance, applied, why would it be a problem after all? Within the union, there is protection. First, there is some harmonization of labor law that applies across the board everywhere in Europe, so it's protective. So why is it that they are not protected enough? So that's a very good question indeed. And I didn't, have time to elaborate on that, but that would be a good idea, because yeah, I think what is actually happening is, due to the mobility, the fact that these workers is very hard to control. I mean, to control in the good sense. The situation is very hard to monitor. Really, what is happening to them is very hard to. So you see the Bouygues, for instance, the Bouygues case. They're on the French territory, but there are workers coming from different places. They will shift. It's very hard to find out who exactly, and the labor inspectors, they don't have so much resources. They are trying to see what is actually happening. They don't get the information, what law applies exactly, and workers are shifted. And so it's hard to, in theory, they could be protected in sufficient ways, maybe, if any law applied to them. But due to the fact that they're shifted around, it's not clear whether actually they will be protected. And you see situations like that, for instance, in the farm sector. There's a big case. I don't know if you heard about that. It's called Terra Fecunda. It's a Spanish company, farm in the farm sector, providing workforce. They provided workforce from Latin America to France, mostly, via a company that is Spanish. So they had this immigration, easy immigration to Spain because of, the particular relationship with Latin America. And then the workers were shifted around, mostly in the south of France. They were taking these workers by bus and moving them around. Very hard to find, to know where they were, to follow, their path, and to actually make sure that the law was respected. So there's a big issue that goes beyond the applicable law. It's enforcement in this situation of mobility. So that's why there's a moment when, to make it efficient, there's no other way than looking at if it's pure provision of services. That's what the Parliament says, by the way. It calls it financial subcontracting. When in fact, like Terra Fecundis, they are not active in the sector. They're just providing workers. It's financial subcontracting. And I don't know about this notion. I had not come across the notion before reading the European Parliament resolution. But they're saying basically this is problematic because, the reason why it happens is probably that you cannot check what is happening with these workers. And then I went to a conference with unions in the sector of construction and wood. It was a couple of years ago, and they had a movie. They had interviewed workers from Pakistan and India, and they were saying Europe is the worst place. They had worked in the Emirates, in Qatar. They had worked, and they said Europe is the place where I was exploited in the worst ways. So you could say, bizarre, because exactly your reaction. How come? We have regulations, national regulation, EU social policy, rules that should apply. And how come they are exploited in these ways? So yeah, it's a bit counterintuitive that they don't get the protection, but I guess this situation of artificially created mobility are situations that are very hard to control and to make sure that workers actually benefit from the law is a real challenge.
We have a follow-on question just before you ask it, Tami, if maybe a follow-up to this very interesting question. It's also something that puzzled me because I thought, well, the exploitation of differences in the rules between member states, so the legal regime is not abusive. That's what the Court of Justice tells us in business or corporate law, in citizenship law. It's fine. It's just that's how the market works.
But did you note, Thomas, that it's different? What the court says in Team Power Europe is exactly the opposite. It's not the Centros line. It says the race to the bottom is not acceptable. Where in the corporation cases, the court says that's the internal market. Yeah. You can choose a place. You can forum shopping is okay, law shopping is okay, and in these cases it says it's not okay.
Yeah, because
so
the Court of Justice also, and that's also a point I wanted to make. Yeah. Labor law takes a different stance. Labor law is very close to the Court of Justice, and it surprises me to see, and that's why I'm also very grateful to you for the presentation, that legislation lags so far behind. We need transparency rules to address the situation that you were just reporting here. We need jurisdiction rules. It's not in place. And on the other hand, we have a very proactive Court of Justice with the Bauer case on but all the way dating back to Marshall has always been very active in the labor and social field, whereas the legislator is just doing bit by bit. So it's a very interesting.
Yeah, but here the court is not acting as a social court. Really, it's bizarre. It's, you know, when it's dealing with a provision of services, it's also it's dealing with cases as an internal market court. That's a bit hard sometimes. Sometimes you see the court. I mean, you think the court, but the court is not looking at cases that involve, you know, free provision of services the same way it looks, and that, hence Laval and Viking, although they are back, you know, to the past. Maybe we can forget about them because it's not today's case law. But still, you know, it's dealing with these social cases through the internal market perspective, and that makes it a different court, I think. Although it is also social when it's looking at social legislation, it's acting very, you know, very much in favor of workers most of the time. This is not the same until the recent developments. Team Power Europe, it's, you know, a couple of years ago. And Bouygues and the rest, it's only a couple of years ago. Although if you look at the situation themselves and the cases which were taken to the Court of Justice, there are many of them before the court eventually says what it says now. And that doesn't mean it would accept, you know, there is a question about the German legislation, you know, that is banning subcontracting in the meat sector. Whether, if it's taken to the court will say, that's fine with the internal market because the Germans have a big problem with workers' protection, that's, you know, mandatory requirements, that's justified. It might also say, well, you're going too far. You know, after all, it's encroaching too much upon fundamental freedoms, the market freedoms, and that's not acceptable to do what the Germans do. I mean, now that we have the European Parliament and the Commission that is getting more aware, maybe the court will align with that. But to begin with, when the German legislation was adopted, many thought, not sure that's okay with the internal market, you know?
Tammy.
Thanks very much. My name is Tammy Harvey. I'm visiting the university, and I think some of you might have seen an advert for a masterclass on legal research that I'm doing later in the month. I have many questions, but maybe I'll email you about some of them afterwards. Just a couple of them. First of all, I absolutely loved your talk, the way that you brought together different parts of EU law that are not often seen together. And overall, the story that I heard, and I wonder if you would agree with this is an example of how regulation really struggles to tackle clever lawyering that's based on contract and corporate form. So if we, the European Union, or we, the state, want to prohibit this kind of thing, the regulation has to get ahead of contract and corporate form. And that was a story that I heard very strongly. Then the other question that I had for you, and I have some potential answers to your last question on your slide as to other examples where this might be happening. But this is the question that I want to ask you. Another element of what's going on in European Union law more generally is reshoring of capacity. And so that's another element of your story. And where do you see that fits? Because the European Union is trying to incentivize production of critical materials within the EU. And this is a post-pandemic thing, but it's also a sustainability thing. So that's another strand. And how do you see that fitting in?
Thanks. Very interesting question. Thank you. So for the first one, yes, indeed. I think it's exactly what you say. A free provision of services has become a business per se. It's not what it was. I mean, it continues to be partly what it was. That is to say, you know, that you have a business in Vienna, and you know, there is a contract somewhere in Paris, and you're as a company, it's great that you can compete to get a tender, or, you know, to get a contract with another company in France, and that's fine. That's good. That's what the internal market is about. But now it's not the same. Now that has become, it had to be. I mean, it's just, it became a business per se. So you're making profit by using free provision of services. That's, you can see that in other domains, tax law, particularly. So it's just, because it's possible and it's legal, why not use it to make it more profitable for companies? So you create this temporary work agency somewhere, and free provision of services goes on, and that's the system, and that's a profitable system. And as long as it's regular and legal, it will go on. So that's why you say, we need to get ahead. First thing is you need to be aware that this is problematic. And I must tell you, for a time, I was telling people at the European Commission, I'm not saying I were, talking to the top, the president, but I was talking to people who said, okay, what's the problem? This is business. This is the internal market. There's no problem. Most firms are doing it. It's okay. They're thinking about engineering. They're thinking about Price Waterhouse. Shifting. Their people around to advise firms on. That of course is okay. And I think even the regulation we have is too heavy for what is okay, but it's too light on what is problematic. That's the thing. It's because it's capturing everything as if it was just one thing. It's very abstract. And so I like it when it starts becoming more, there are high-risk sectors. We see that some companies are making this a business, and it's not, because they have a business that they want to expand. That's another story. So we need to distinguish, because otherwise it's not working. It's too, it's indeed too burdensome for some corporations that are trying to do good, but it's uselessly heavy, and it's not working for Terra Fecundis, Bouygues, and etc., which could do it differently for the good of everyone else. So I think this question is super interesting. And the second one, no, I don't remember. Yes, I totally agree with what you said. That it's aligned. If we're trying to limit the length of the chain of production, which might derive both from the internal market perspective, free provision of services regulation, and from sustainability. Sustainability, now of course it's shrunk to the first direct relation in the chain, mostly, not completely. But if you actually take it as the requirement for the principal operator, the leading company, to control the whole chain, the inevitable outcome, I think, is it will bring some of the production within the union or closer, because otherwise it's very hard to control. And it depends. And again, when saying that, it's too general, because it will depend. Sometimes there is no choice. You need to have to offshore. I mean, in some sectors, it will be very complicated to bring the production within or closer to the union. In some domains, it's feasible. So it will have to be managed in, I think, subtle ways. But I agree with the idea. Thanks.
That is the ideal final word, but we do have 2 minutes or 2 questions. 2 minutes. Yes, that brings us therefore to an I'll skip my own questions. And thank you very much again, Sophie, Professor Robin, for coming and discussing with us. Thank you very much. And thank you again to everyone who participated in the event. Have a good day.
Thank you. Thank you. It was really nice. It was really nice to have you.
I have my next appointment at 3.
Yes.
But would you like to head out for coffee? Oh, okay.
Oh, that's nice.